The past 48 hours have been an absolute whirlwind for crypto legislation in the United States. We're going to take you through the biggest and most important points laid out and try to understand exactly where this legislation is going. Let me be clear, we're starting to see the signs of some of the biggest wins for the crypto industry as it pertains to legislation, as it pertains to regulation that we've gotten to see since the beginning of the crypto industry. And this is because the Hinman docs have just been unsealed. Before we get to that, we have to acknowledge and pour one out for Warren Davidson, obviously one of the most pro-crypto politicians in the game. Pour out those 40s for Mr. Warren because he has filed a bill to actually fire Gary Gensler and restructure the SEC such that any chairman cannot take the entire US capital markets into their own hands. This would be a wildly dramatic step. I don't think anything like this has ever happened to any SEC commissioner in their history. Again, people are cheering this. This post alone is 4.1 million views, nearly 50,000 likes. We don't know if this is political theater or what it's going to do, but I will say that in the context of Congress trying to rein in the chairman, what it could do is actually impact the court cases going on. So you have the SEC on one hand, they can continue suing. This could take a long time before it actually impacts the structure of the SEC, maybe years, but it could materially impact the way judges feel about ongoing cases. And it could actually make judges in federal cases more likely to give Congress time to act, knowing that they are trying to act to take over this process. It could make it more likely for judges to say, you know what, we're not going to come in with summary judgments here. We're going to either dismiss or sort of go for much lower judgments while things are being ironed out. In my opinion, this is the biggest W, is that this could lead to better treatment in the courts, knowing that there's a public campaign from sitting congressmen to actually rein in the SEC. Interesting stuff here. Very unclear how this plays out though yet. So I wouldn't get overly excited, but it's a very interesting piece of information. All right, let's get to it because this is the news of the day. The Hinman docs have just been unsealed. This is in the Ripple XRP versus the SEC lawsuit, and this has been a sticking point for literally years. And this is because in 2018, there was a speech given by the SEC's Corporate Finance Division Commissioner Bill Hinman. And unlike other examples, these statements gave some pretty significant and clear guidance on what would or would not be considered a security. The CEO of Ripple, Brad Garlic Bread himself, has said that they are well worth the wait, these documents. They already knew what was inside them. They just wanted to get them unsealed publicly for the record. But let's go to actual lawyers for the breakdown here so we can understand the implications of these documents. We've got our usual lineup here. We got our bad boy Adam Cochran, we got newbie Austin Campbell, and we got OG GOAT Gabriel Shapiro. Let's get into it. So first and foremost, people are saying that the Hinman docs date back to when ETH was proof of work, and he's going to address that. But it's important to realize that the statements were not directly tied to proof of stake versus proof of work. Hinman's guidance in his speech certainly went beyond the scope of the Howie test. Now, this is a huge thing because Gary Gensler has been pounding the pavement trying to convince us all that the 1933 Securities Act is all we need. And that was the Howie test, right? Where they were selling contracts for the future profits of orange groves. And those were deemed to be securities. Now, this is really important because according to the current chairman of the SEC, that is all we need to regulate this industry. But what Hinman's guidance seemed to suggest was that we actually need to go further than that this is not adequate. And this is what the crypto industry has been begging for, saying we need more rules here. We need more guidance here. And the current SEC is saying, no, we're going to go with the previous guidance, which is very open-ended, kind of allows them to play sort of God King here, deciding what is and what isn't a security. Hinman apparently was very fixated on the idea of morphing, that something can begin as a security and morph into a commodity or a non-security. This is exactly what he argues happened with Ethereum. It was sold as a security, and then it reached a point where it became a commodity. This is a huge idea. In fact, he was so fixated on it that the original, you can see the strike through at the beginning of the title here, was digital asset morphing, and he changed it into digital asset transactions under the Securities Act of 1933. And then I don't know what this is, something witty and snappy. I guess this is what he was actually placeholdering there. Yeah, super witty and snappy there, brother. Yes, I'm on the edge of my seat. Now there's a huge W in here for alleged promoters of cryptocurrencies. And this is because the term promoters, as Hinman defines them, is actually too broad in the generic sense. In fact, he says that you're not actually a promoter unless your actions are deemed essential to the network. So a promoter, for example, cannot be just a YouTuber. And this really hits to the idea of people like myself who talk about cryptocurrencies and the idea of whether we can be considered, quote, promoters of those cryptocurrencies just because we talk about them or invest in them. This is where a ton of legal gray space has emerged. But now it seems to be that Hinman defined a promoter as though you have to have essential efforts to developing the protocol itself. So for example, if I buy Ethereum and talk about it, I can't be considered a promoter of Ethereum. No, you actually have to be a core developer. And it can't just be that you build on Ethereum. It would have to be that without your efforts, Ethereum would no longer continue to exist in its way. This is a massively specific thing, and this will really open up the climate as to who can talk about what in the cryptocurrency space. Next up, we have something absolutely massive, which is that Hinman points out something Gensler has seemingly forgotten. In Howie, orange groves themselves did not become a security, even though the sale of the future profits of those were. Okay, so this is a little bit nuanced, but the idea was that people were selling the interest in future profits from this piece of land, these orange groves. Effectively, the orange grove itself wasn't the security. It was the contract, the agreement for future profits from that orange grove. So nowhere in this process did the actual orange grove become a security, but a contract based upon its future productivity. Now that is a security. So the question is, in these lawsuits, are we talking about the actual assets being securities, or are we just talking about derivative products? Now you can start to understand how futures markets, longing, shorting, options, those might be securities, whereas the actual underlying assets, Bitcoin, Ethereum, and other crypto assets very well might escape the securities definitions with this huge new piece of data. Remember, the future contract is not the same as the underlying asset. This is a huge thing, and I hope this was a clear explanation of it. Remember, though, I almost became one. I am not a lawyer. It goes on. The digital asset itself is simply code. It's the way it's sold as an investment contract that can be a security. Now, this gets down to the core of the matter, which is that when the digital asset is sold is really the only place in which the SEC has some jurisdiction. For example, there's a lot of coins that began with really tiny market caps and really tiny token sales that ended up growing to be massive. Now, in those particular events, the way that the asset is transacted post that launch is actually far less important than pre-launch. This is a massive piece of data and cannot be overstated, because if this becomes the actual law of the land, then essential free launch tokens, airdrop tokens, all of those things become very hard to pin down under a securities analysis. Again, this shows the desperate need for new clarification, new guidelines to guide this fast evolving industry. And then we get the bombshell, the one that has Bitcoin laser eye maxis crying their laser tears. No, at this time, Hinman decided in 2018 that Ethereum was not a security. That was his view. And Ethereum has only grown to decentralize more since then. This is a huge show-stopping W for Ethereum. Make no mistake that the case for Ethereum not being a security has increased 10, maybe 100-fold since the unsealing of these documents. And the fact that that is the case for Ethereum essentially paves a path for other crypto assets. This is a huge, massive, king-size double whopper of a W for not just Ethereum, but the entire crypto space. We've also seen time and time again that secondary sales on markets are not viewed as sales of securities. We saw this even in the Library case, where Library got their butts handed to them by the SEC. They still earned the qualification in the judgment that secondary sales were not considered sales of securities. This is huge. Okay, so getting to the point, one of the reasons they didn't want to call Ethereum a security was its practical use as a gas token. So being used as a gas token was fundamental in this analysis. We can extrapolate from this that any token used as a gas token in some way for some application or some network could then start to fall under this analysis. This could be an absolutely massive change to the way that crypto protocols are actually designed in order to fit this designation. I know it's getting a little bit arduous here, so here's a picture of a very cute seahorse. If you do enjoy this seahorse, make sure to like the video. We're gonna get back into the legal analysis in just a second. I just want you to know I'm really proud of you guys sticking it out this far into a literal legal analysis video. Look at you. I'm really proud of you. We're actually going to skip Austin and Gabriel and go straight to Paul Grewal, who is the pretty much he's the top lawyer at Coinbase. The regulatory gap. Proof from the Hinman emails of what we've been saying to the Third Circuit, to Congress, and to the SEC itself, that security laws are incomplete when it comes to digital assets, that security laws aren't meant to rule over all digital assets, and that many digital assets are not securities. Obviously, one of the most maddening parts of all of this is the fact that all of these videos continue to surface from Gary Gensler himself acknowledging that Ethereum specifically and other crypto assets are not securities. Take it from Double G himself.
Over 70% of the crypto market is Bitcoin, Ether, Litecoin, Bitcoin Cash. Why did I name those four? They're not securities.
So as prices continue to slide, and as we start to see more and more fire sales here in the crypto asset space, well, my strategy is pretty clear. I've long believed that regulatory arbitrage is a huge opportunity for savvy, experienced market participants to take advantage of emotions and fear from those who are newer in the market, who might think that this time is different and this industry is somehow just going to disappear. The reality is that it is not. China is moving full force, inviting cryptocurrency companies to come bank and speak with official government regulators. The goal from other jurisdictions is very clear: to give a hospitable home to cryptocurrency and its developers. The UK is doing it. The UAE is doing it. China is doing it. And we can assume that with their leadership, others will soon follow. God knows there is an absolute titanic amount of tax revenue to be collected from cryptocurrency developers and companies that have success in the space and employ hundreds, if not thousands of people. The future is bright for cryptocurrency as an industry. And this moment of darkness, I believe, will continue to present some of the most important opportunities. Yes, I have been DCAing slowly. Yes, for a lot of assets, we were at lower prices than when I started to DCA. So I will continue to do so more. I will eventually, if we get another big dip from here, probably start buying with a little bit more size. Because if we dip much lower to here, especially if we get Bitcoin back at that sub 20K level, I believe that alts will be on absolute dumpster fire sales, and I want to get my hands all over those, especially as people have significant doubts as to the future of the altcoins. That's when those life-changing discounts really start to emerge, when people think this stuff is hot garbage and it ain't never coming back. As always, if you enjoy these videos, you know what to do. Watch this video popping up here. It's even better than this video you just watched. I'm EllioTrades, and I'll see you very soon on the next episode.